Trainings. Just a couple reminders before we get started. We ask that you keep your microphones and your videos off during the presentation. If you have questions, please type them in the chat box and I will relay them to our presenter as we go along. So today we have Adele Page with Legal Services in North Dakota, and she is presenting on the eviction moratorium.
Are we ready to go?
We are ready.
Okay. Well, good afternoon. Thank you all for joining on this important subject that has a lot of gray right now going on. So as Kylie indicated, you know, questions are welcome. I think that's going to make this more interesting for everybody in terms of trying to figure out where we are. But without much ado, let's proceed as I try to get my slideshow going, which it is not working for me. Give me a moment. All right. So when we talk about eviction protection throughout the COVID pandemic, we know that in the beginning, we had some North Dakota protection that expired sometime last summer, quite a long time ago. And the federal government did step in September of 2020 and issued the Centers for Disease Control issued an eviction moratorium based upon their regulatory authority to protect against communicable disease. That eviction moratorium originally took place, I believe, September 4th of 2020. It has been renewed and it was to last until the end of December of 2020, was renewed through March and has now again been renewed through June 30th of 2021. And as we all know, today is June 1st, that's very soon. It could be extended, but we really don't have any great predictions. I would not be surprised if it's not extended. So that will be an interesting situation as it dies, but it is possible that it would get extended until September again. Again, there is also, in addition for landlords, substantial rent relief money that has been issued through the stimulus bills in two different bills, and most of that money has not actually been seen by many landlords or tenants. So I think that we'll see that coming down the pike. Exactly what the system to receive that money will be, we will see, but it is slated for state distribution. To talk about the CDC Eviction Moratorium, which I'm going to almost count on that many of you already know a fair amount about it because it's been around now for quite a while. It is in the state of North Dakota, it is our sole eviction protection in COVID. States such as Minnesota, which are close to where I live, they have an ongoing state eviction moratorium, which actually has higher protections than the CDC Eviction Moratorium. And therefore, the CDC Eviction Moratorium really doesn't impact those landlords or tenants. But the key thing here is a tenant is at risk for eviction or being evicted for non-payment of rent. It only applies to residential tenants. So if commercial tenants, not applicable, and the tenant must provide a declaration under penalty of perjury. They don't have to have it notarized. They need to sign it and attest to certain facts. It is unclear and differs state by state how a landlord or a landlord's attorney might attack those facts. But in essence, most of the time, in my experience, when a tenant has signed a declaration, provided it to their landlord, if the eviction proceeding has already started, provided it to the court, then the eviction has generally stopped unless there are other reasons for that eviction in addition to non-payment of rent. And we should talk about those. But in essence, the tenant has to attest that they have made best efforts to receive government assistance to pay their rent. And that can be in North Dakota, Rent Bridge, which I'm sure most of you are familiar with, or other assistance programs. And the details are a little bit more complicated, but they have to essentially expect to earn less than $99,000 in 2021, or if they're in a joint filing status, $198,000. So this applies to most of the tenants that we see in residential renting situations. So far, I haven't come across anybody, but then I work for Legal Services of North Dakota who has been over income. Sometimes it's whether they received a stimulus check or things of that nature. There's a little bit more language to that bullet, but most of, I think the base, you have to, essentially the income levels are the floor that most people are easily able to look at. There needs to be a substantial loss in household income. It doesn't have to be due to COVID. So you don't have to establish that you are out ill from work because of COVID, or that you lost your job because of COVID, but there has to be a substantial loss in household income. And that loss doesn't necessarily have to be wages, although it most commonly is, but sometimes it could be high medical bills or other things that make your income substantially lower. The declaration says that the tenant is making their best efforts to make partial payments, and absent the application of the Cdc Eviction Moratorium, that individual will be rendered homeless, or, and I think most importantly, because most people have some place to go, they would end up in some sort of congregate living situation, living with their brother, their sister, their mother, their father, and the closer the quarters are, the concern is that that's not good, obviously, in a pandemic. So keeping the congregate living situations smaller is important. And those are the attestations. There's actually a very nice new declaration form that the CDC issued. I believe it was after they extended it on March 30th. It's a fill-inable form. It's easy to find. And it just kind of walks the tenant through whether they qualify under this language. You all may know that there's actually been a number of constitutional challenges to the CDC Eviction Moratorium. When I remember in September, when it was first effective on that September 4th date, I think we heard about it in the end of August or early September. I questioned how it would withstand constitutional challenges. It was an unusual thing for the CDC to do, to use its authority in the communicable disease pandemic world to talk about housing. Nevertheless, they do have some pretty broad regulatory authority in this area. I did not list all of the challenges to the CDC moratorium, but they've happened in a number of states. In the vast majority of states where the court has ruled that it is unconstitutional, that finding of the court has been limited to the plaintiffs in the case. So for instance, if ex-plaintiffs file a constitutional challenge, and usually it's some sort of organization, then it would apply to protect, say that it's unconstitutional as applied to them. However, the District of Columbia's district court, which is their appellate court level, it's not their appellate court level, it's their trial court level, but their federal trial court level, Alabama Association of Realtors filed a case there, and the district court in the District of Columbia found it to be unconstitutional and opined that it would have broad application. In other words, statewide, national application. I think that the Justice Department disagrees with that holding and basically argues in their argument for a stay that there's no application outside of the District of Columbia. I don't know the answer to that. I think the courts are going to have to fight that out, but it right now isn't worth really arguing that legal issue because there's currently what's called an administrative stay pending appeal. There can be a more permanent injunction pending so this case is being appealed to the Court of Appeals over the District of Columbia. And while it is being appealed, it's currently stayed with an administrative stay, which is a lower level stay. We will see if it gets overturned at the Court of Appeals or the district court level, or if they apply for what's more likely a more permanent or what we call a temporary injunction, which has more teeth than an administrative stay. But regardless, right now, despite the holding by the District of Columbia in the Alabama Association of Realtors, the CDC moratorium remains alive and well. And this all may become what we say in the law is a moot point, because if in fact the CDC moratorium expires on June 30th, I doubt that it will get anywhere between now and then. So, and it's important to realize a couple of things. I've seen some arguments from landlord attorneys recently saying that the CDC moratorium, there are some frequently asked questions, they are not law, that the CDC issued that says, contrary to the plain language in the order, the CDC has opined in these frequently asked questions that the moratorium doesn't prevent an eviction, but merely prevents removal from the premises. So when you undergo an eviction in North Dakota, there's judicial process. You serve, particularly for non-payment of rent, you'd serve a 3-day notice, and then you don't get paid. Then you serve a summons and complaint. You go to court in an expedited proceeding that happens pretty quickly. And the judge gives you, I believe it's a maximum of 5 days to get out, although often it's quite a bit less than that. If you don't get out, then the landlord can apply for you to be removed by the sheriff. And what I saw recently in an eviction case is the attorney arguing that they could proceed with the eviction. I think the attorney realized that the constitutional challenge doesn't hold any teeth, that the CDC declaration still was in effect, but he wanted to get the eviction done so that as soon as the moratorium expired, that person could be removed from their household. However, I'll be honest with you, I responded in my answer to that challenge that in North Dakota, you can't maintain an eviction unless it is to obtain possession of that property. So for instance, if you file an eviction against a tenant and the tenant, cleans up the housing, returns the keys, takes all of their property out of there, completely returns possession before that eviction proceeding, then the landlord's remedy is for the past due rent, probably in small claims court or district court, because they've already obtained possession of that property again. So my response to the frequently asked questions issue is that, first of all, frequently asked questions are not law. I think that the plain language of the CDC Eviction Moratorium says it applies to all stages of an eviction proceeding. And in North Dakota, there is the notice, and then the summons and complaint, there's the actual judicial action, and then there's the removal from the property. But in North Dakota, it is, besides the fact that I don't think that the frequently asked questions are law, in North Dakota, because eviction is an action for a possession, I don't think that that's a good argument for the landlord's attorneys. There's some open questions that I think are worth talking frankly about, and that is with the federal CDC eviction moratorium, Does it apply to, I'm on a month-to-month lease? Does it apply to you saying, well, you haven't paid your rent, so I'm not going to renew? I give you the appropriate statutory notice, the full calendar month's notice, and I want you out. And so does that apply? I think that there are some arguments in both directions. And our district courts have not, we don't have a Supreme Court decision on this issue. I'll be honest with you, in North Dakota, our district courts are deciding this issue in different ways. But I think that there's an excellent argument that it should apply to non-renewals because in essence, if the reason for the non-renewal, even though you don't have to give a reason for non-renewal, is non-payment of rent, that it violates the scope of the CDC Eviction Moratorium, and in addition doesn't fall into any of the exceptions. I think there's also an argument that the CDC Moratorium has nothing to do with a lease non-renewal. So if I were a judge, I'd want to listen to the arguments in both directions. But that's an open question. It has been resolved in other states in both directions. The CDC moratorium has actually a number of exceptions that the courts do look at. And I try to just briefly list them here with bullets. And they're obviously criminal activity on the premises. Even Minnesota has an exception for that type of thing. Activity that threatens the health or welfare of the other tenants. And I think the question always is less so for criminal activity, more for threatens health or welfare. Like, at what level does this apply? What is smoking outside, violating the smoking rules? Does that apply? Or is it something that's really quite a bit more dangerous? And again, we're seeing our district courts here decide that issue differently from judge to judge. Damage to property is an interesting one. We have seen challenges saying there's been relatively minor damage to property, therefore the moratorium doesn't apply. And there's arguments that that's a subterfuge around the language of the moratorium. It should be something more substantial. And again, our courts are deciding it differently from judge to judge. I think simpler is violations of building codes or health ordinances or similar health and safety regulations. If you can show that a tenant has plainly violated something that our local jurisdiction has said is important for the safety and welfare of those tenants, that's easier. I do think that the threatens health or welfare, damage to the property is a big wide door. And I have had judges just say, no, that doesn't count. That's not significant enough, because obviously we are seeing those being raised in addition to the non-payment of rent. Contractual obligation, this is the other big, wide open door, other than, so contractual obligation other than rent, fees, penalties, or interest. So is this the question on this last one, number 5? Is it any material violation of the lease other than non-payment of rent, fees, penalties, or interest? I don't know. I think it depends upon the state, the judge. I would argue that it would have to be a material violation, but not just any contractual violation. But those are still open questions. We have no higher level findings in the state of North Dakota. We have a number of district court judges seeing these cases, and they're all coming out slightly different. We have judges in some areas of the state who are basically hearing eviction actions, but then continuing them until the CDC moratorium is over. We have judges just simply dismissing them. And that's hard for those of us who work in this area because it's just so different from area to area. but I'm going to be candid about it. That's where we're at.
We have a quick question.
Absolutely.
I have an agent for a landlord that wants to evict the family because they leave garbage out in the bag and toys in the yard. Can they evict for that?
I think we're right back to exactly what I was talking about. Is that significant enough? Garbage out in bags, toys in the yard. I think the vast majority of judges are going to say no. Could there be a judge who says yes? Maybe. And I think that it amount to the level of proof. Is it actual damage to leaving toys in the yard? Probably isn't damage to the property. Garbage probably isn't damage to the property, but if the garbage is attracting rodents and varmints and things like that, then maybe. So it's very, very fact specific. Does that help? Hopefully. Any other questions?
Not right now.
Okay. So it is important to realize that there is some teeth in the CDC eviction moratorium. Essentially, you can't bring a civil action under it, but there are criminal penalties, and individuals have maximum fines of up to $100,000, 1 year of incarceration, or both. For companies, the consequences can be quite a bit more significant. Maximum $200,000 fine per, and these are per eviction. So they can really add up. Lately, just recently, as of the beginning of May, late April, the Consumer Finance Protection Bureau and the Federal Trade Commission are actively investigating multi-state landlords, eviction management services, and private equity firms. So they really have changed their tune, but their focus isn't on small landlords. The focus really is on these multi-state landlords and multi-state systems. And we're going to talk in a bit about some of the teeth that they're trying to create in terms of getting notice out. One of the things those of us who represent tenants have been acutely aware of is that this is an affirmative thing that tenants need to do. So a landlord can go ahead and evict a tenant for non-payment of rent. And if the tenant doesn't raise their hand and give that landlord a CDC declaration, the landlord's doing nothing wrong by evicting. And that is something that has seemed to be a hole, because obviously not everybody knows how to find the declaration form, or knows how to complete the declaration, or even knows if it applies to them. And so we've seen a lot of variety there as to how that's being done. But clearly, there's now some focus on large companies. I also do not know, under the CDC Eviction Moratorium penalties, I have not read or seen very many cases coming out of those consequences of a violation. So June 2021, are landlords evicting? I've looked all over for statistics because I think this is such an interesting question. There is one place where I read evictions were down by 23% in 2020. This is the National Housing Law Project that cited that, and those were statistics for North Dakota. In 2021, we can look at anecdotal data. We can look at local court records. Numbers seem to be increasing, but I'm not going to swear by any of those numbers. I feel as if it's not over until it's over. We need hard numbers from the court system, and it's very difficult, at least with the tools that I have available, to go in and look at eviction numbers and make sure that those evictions are truly due to non-payment of rent. But according to the National Housing Law Project, which is a national entity, numbers were down in 2020, although I will tell you, since remember until, I'm not sure I'm going to have my dates exactly right, but we had a state eviction moratorium effective through sometime towards the summer last year, and that would obviously do it because that was very clear cut. And then the CDC declaration came into effect in September, and there was a real learning curve. We didn't really see people filing those until October. So not really sure what those 2020 numbers are about. In 2021, I think there's a lot of frustration about all these non-payment of rent cases. I am very eager to see the flow of money coming from the recent stimulus bills towards payment of rent and towards getting those landlords made whole, in addition to protecting the tenants who are in those housing situations. I don't know what's going on with my screen. Give me a moment. Okay, so I don't know how many of you are aware of this, and I referred a few minutes ago to the Consumer Finance Protection Bureau, and it's an agency under the Federal Trade Commission, and it issued an interim final rule that became effective May 3rd of 2021. And what it did is it required debt collectors to provide written notice to tenants of their rights under the eviction moratorium, and prohibits debt collectors from misrepresenting tenants' eligibility for protection from eviction under the moratorium. So this is intended to directly address that issue of tenants not knowing that they have potential rights under the CDC Eviction Moratorium. And so the FTC has limited authority. I mean, it's just like the CDC has limited authority, but it's using its authority over debt collectors to say, no, if you're going to ask, try to get money from a tenant who's for non-payment of rent during the eviction moratorium, or do any of those actions, you need to provide a formal notice of those actions. And I'm going to show you some examples of those notices towards the end of this presentation. And in fact, here we have quite a bit more teeth. Debt collectors who fail to give notice may be investigated by the Consumer Finance Protection Bureau and prosecuted for a violation of the Fair Debt Collection Practices Act. But unlike the CDC moratorium, they're also subject to private lawsuits by tenants. So this is something that should wake up any attorney who actually does a regular eviction practice. And that's the dicey thing, because when I first heard about this, and it was early May before the issuance of the interim rule, and I heard the director of this agency explaining what they were doing, the question was, but does it apply to attorneys or landlords? Who does it apply to? And it applies to debt collectors as defined under the Fair Debt Collection Practices Act. And that includes an attorney who regularly does eviction law. So the purposes of most eviction law is to get that landlord made whole and their rent to be paid. And that according to the Cfpb and the FTC, an attorney who regularly practices in that area would qualify. So we're starting to look for, at the end of an eviction notice or a 3-day notice, one of the formal notices that are required by the CFPB or the FTC. Now, I think I have this on the next slide. Let's hope I do. It's not just the investigation by the CFPB, because obviously they can't investigate every eviction practice in the country, but it also is, and I did not have it on there, reportable to the Attorney General's office for prosecution. And also, again, I think that there may be some teeth in that private lawsuit language that we're going to see coming down the pike. So again, notice must be given with the eviction notice. It must be given in writing. And I'm seeing more and more things happen in our world, not just in the eviction world, that are by text or email. The language is extremely clear that it must be given in writing, but not by electronic means. So as I understand this, it absolutely needs to be on a piece of paper, which is different. So no text messages, none of those things. And I'm going to show you a sample notice momentarily, but let's go on to show you this rule about attorneys. The Consumer Finance whatever bureau has authority under the Fair Debt Collection Practices Act to prescribe rules with respect to the collection of debts by debt collectors. And again, attorneys who engage in eviction proceedings on behalf of landlords or residential property owners to collect unpaid residential rent may be debt collectors as defined under the Act. So if I would argue that if an attorney does one eviction case a year, they're probably not a debt collector, they're an attorney. But if it's a regular part of their practice, that is a different ballgame. So with the exception of showing you my sample, language, which I think is important, I tried to leave as much time as possible for questions. And this is a very quiet room, but so the Consumer Finance Protection Bureau has put out a very nice little brochure, which I have here on my screen, that gives the sample disclosure language, and it should be at the end of an eviction notice. Example one may use if they're disclosing that a consumer may be eligible for temporary protection solely under the CDC order. And you'll see it's really quite simple. They want it bolded. Because of the pandemic, you may be eligible for protection under federal law, and they just give a website or a phone number. So they don't attach the declaration or anything like that. Another example is, this is just same idea, state, territory, locality, tribe. They're just slightly different. And then of course they give also some examples in other languages. So obviously if you're going to be working with somebody or serving somebody who you know does not speak English, I don't know of any language in the order that requires that you put it in their native language, but I would suggest that particularly if it's something that's accessible, that it would be good to do that. But that's where we are right now. We don't know a lot. We don't know what's going to happen June 30th. We don't know when the money's all going to come out from the various, from the states to landlords, but I think there's going to be a lot that happens in the next month or two. And without much ado, that's what I have, other than I'm very happy to answer any questions that anyone has.
Could you go back to the slide that is the beginning of the CFPB's requirement of notice?
In here or in my slide deck?
I believe the slide deck is what they're
okay.
wanting.
All right, let's go. Is this the one you're talking about?
Might be better if I unmute myself because I'm the one asking the question here. Yeah, I missed the part where you started talking about what notice was required. So maybe just up slide 8, maybe.
Okay, we're there.
Gotcha. Okay. And then Adele, you were trying to show a brochure, but unfortunately that brochure didn't come through on the screen that we were viewing. Could you go back to where you found that?
I sure can. Thank you so much. Yeah, let me, because I think that that's important, because I think it's good guidance for, yeah, let me see. I'm wondering if I can send out a link for everybody to
get. That's what I was wondering. If you could put in chat where you're going, that would be awesome.
I would be happy to do that. I'm sort of messy at this, so you're going to have to all forgive me. Can you see everything I'm searching? I can answer questions while I'm, this is really the, I'm wondering if this is a PDF. I downloaded it. What does it say? Cfpb debt. Language, I like the notice because it's simple. Hold on.
Adele, it seems like a landlord that's not using an attorney, would they be required to provide this notice as well? Or is it just somebody who's trying to collect the money?
It's got to be a debt collector, so the landlord would not qualify. We asked that specifically when we were in front of the agency head. So would not apply to a landlord if they were doing it themselves.
But most of them do use some sort of an attorney, so that just adds a step onto that process then, right?
Correct.
Yeah.
It's very interesting. And I think that, so you have to remember, these are the federal agencies trying to figure out how to, let me put it, my computer is not being very kind to me. I'm just going to tell you, if you look at debt collection, sample COVID-19 tenant eviction protection form, it's right there. And I'm getting a failed opening on my computer, but
Adele, you could send that to me via email. Oh, there we go. Something came through.
Did it?
I think I found the website.
Okay. I can send it to Kylie. I can just drop it in if that's helpful. It's pretty easy to find, but it's a nice document, and it just gives you sample language to use. I have it in PDF, and that's the problem. I don't know how to send it to you all. I apologize. I don't know why this isn't sharing. You can't see that when I have it up?
All we can see that I can see is your slideshow.
All right, maybe I need to take the slideshow down. Sorry, everybody. No. All right, I'm an idiot. Sorry, everybody.
Well, Adele, just to follow up on it. So this is kind of a new requirement. And have you heard courts are looking to see if somebody received this notice, or you got to be a smart tenant to know that you didn't get something?
I think that's an excellent question. I sincerely, is that up there now? Can you see it?
Yep.
Okay, sorry about that. I think it's an excellent question. I doubt that our courts are looking for it right now. I have, remember, it's not the court's responsibility. And again, the debt collectors are supposed to be understanding that they're at risk if they don't do this. Although, once again, I'm not sure how widely known this is. I did file an answer about a week or two ago, basically saying you didn't comply with this. So I know that there's an attorney in our Bismarck office who's doing the same. So there are us legal aid attorneys looking out for it. But I agree. I don't think the tenants know that they need to look for it. I don't think that they know. But the reality is, if you don't do it and somebody picks it up afterwards, they can go to the AG to, there's a private lawsuit potential. All of those things are there. But I just want to check. Can you see my screen now that it's up?
I can.
Yes, we can see it.
Okay, so sorry about that. I think it's because I probably left my slideshow open. But yeah, I mean, all of these things there's lots and lots of laws and regulations out there that don't get enforced. But this is out there. And, obviously if a landlord does an eviction themselves, not a problem. Most landlords go to, there's usually, I'm not going to name names, but in every jurisdiction, we know who the law firm is that generally does the landlord tenant eviction work. And those are the ones that are at risk with this.
We have a couple of questions. You mentioned smoking in the beginning. If a client is in a non-smoking building or they are HUD subsidized, a landlord can evict for smoking, correct?
No, I didn't say, well, ask the question again. Let me hear it carefully.
If a client is in a non-smoking building or they are HUD subsidized, a landlord can evict, correct? If they're smoking, evict for smoking.
Well, I mean, that's a violation of their lease. And then the question, and it's also probably a problem for the peaceful enjoyment of the premises, so that there's language under our eviction statute that certainly would allow a landlord to go forward and do that. The smoking issues really come around when a premises changes to a non-smoking premises while the person's on a term lease and there's no basis to have them sign an addendum. But if they have a lease that says that the premises are non-smoking, and that's a violation of the lease term, and it would likely be a material violation. So sure, you could evict.
With the exception, oh, hold on. Sorry, with the expectation of the end of the moratorium on 6/30, it would be acceptable to issue a 30-day lease non-renewal today and ultimately take it back if the moratorium does get extended, as long as the verbiage and disclosures are provided?
I would say a full calendar month's notice. Not 30 days. That's what everybody says, but it's a full calendar month's notice. But yeah, I think you can always take it back, and we'll find out what happens.
If the tenant received a stimulus check and didn't pay on their rent, will that be against the family?
Yeah, those are all back to issues of proof, right? So there's nothing in the CDC moratorium or in any language that tells you how you're supposed to use your money. You are supposed to make best efforts to pay your rent and to seek government assistance. So if in fact a landlord could prove that the person wasn't making best efforts, and part of that evidence is that they got a stimulus check that they spent on a new car, that might be good evidence in eviction court, but that's all an evidentiary question.
So far, that is the last question.
Okay.
Oh, let's see. There's kind of kind of a follow-up. They're still typing. But if the family is getting evicted and has no income, does the eviction moratorium still apply?
Family is getting evicted and has no income, meaning they can't make best efforts. Yeah, it still applies. They would be expected to apply for whatever government assistance that there is available to them. But sure, then that's the case with a ton of these, that there's zero income. And I think there's the key here is, are they whatever their best efforts are, and if they've got zero, then their best efforts are zero. They're not expected to borrow from their mom or dad.
Is the moratorium for all landlords, including private landlords?
Absolutely.
And then timing of CFPB notice. When do you think that attorneys will give this notice to tenants?
It's supposed to be on the eviction notice. So traditionally in most evictions for non-payment of rent, you see a 3-day notice being given, often by the landlord, because it's a requirement under the statute. I think that most landlords know that they are required to give this 3-day notice. It's basically an opportunity to cure. But then when they come around to serving, rent isn't paid, a summons, a complaint, then they usually go to an attorney, and that's probably what's going to trigger this. And appropriately, I would say that the language you're seeing in these boxes should be on the bottom of the either the summons or the complaint. I would put it on the bottom of the summons, frankly.
What if a landlord claims the eviction moratorium that was signed by their tenant doesn't apply to her property? The landlord said this doesn't hold water.
Well, they're wrong. And they probably would need to bring that to the judge. Just because they don't like it. I mean, the landlord might start the eviction proceeding if it's a valid declaration, and it has to be valid. And every time I've ever talked to anyone about this, I said, you absolutely have to be able to truthfully attest to all of those things. But if it's a valid declaration, it protects them from eviction. And if the landlord doesn't like it, they still can't get somebody out of their property without going through judicial process. And that means they have to get in front of a judge, and the judge should know that it applies.
Are there any more questions that anybody has? We still have a few minutes, so. Here's a follow-up to the one question. To follow up on that, if a landlord refused to accept the declaration, tenants should do what for proof of serving?
You know, that's a good question. There is nothing in the declaration that says that. So, you know, typically in judicial process, we do affidavits and certificates of service. There's nothing like that. But my comment to a tenant is always have some sort of proof that you provided it to them. And that could be make a copy and write on your copy when you handed it to the landlord. If the case is already in court, my recommendation has always been that the tenant should give it to their landlord and file it in court. Make sure the judge has another copy in front of them. So I don't think they need to do an affidavit of service or anything like that, but they do want to somehow establish that they provided it to them. If the landlord says, oh, I'm not touching that, they can still mail it to them.
I may have missed the section where you touched on non-renewals. Does the moratorium have any protections against a non-renewal or non-renewal of lease?
Well, I did discuss that, and it's an open question. So I think there are excellent arguments that it applies to non-renewals because there's nothing in the exceptions. So the way a non-renewal works is the landlord doesn't renew the way eviction would come around. Because remember, it's an eviction moratorium. In a non-renewal situation is my landlord sends me a month's notice that they're not renewing my month-to-month lease. I say I'm going to give them a CDC declaration because I believe it's about non-payment of rent. The landlord then files an eviction against me as a holdover tenant. Right? I'm staying, I don't leave after my notice, then I'm a holdover tenant, and that's the basis for eviction. A non-renewal is not an eviction action. So that's the strange thing about this, but you're a holdover tenant, and I think you'd have to go to court and establish that the reason for the non-renewal was non-payment of rent. It's very circular, very judge specific. I think that you could very easily lose as a tenant on a non-renewal claim in front of a judge, and you could very easily win. So I know that's not a great lawyer answer. It's just the way the world's working right now.
All right. Well, I think we will wrap it up today. Thank you, Adele, so much for presenting for us.
You're very welcome.
We had a large turnout today, as I know this is a very hot topic right now. So thank you again. Thank you all for attending today. And for those of you that are continued to sign up, our next topic is the criminal guidance, which will be next Tuesday. Again, thank you all for attending and hope you have a good rest of the day.
You too.
Mm-hmm. Why are you in your jammies again? What? Why are you in your jammies again?